Hi, my name's Jim Snow. I've been asked to present a paper today on the lessons we can learn from Australia's largest net zero greenwashing federal court case. So the shareholder activist group, the Australasian Centre for Corporate Responsibility, alleged that Santos engaged in misleading and deceptive conduct towards investors. This was in relation to its plans to reach net zero emissions by 2040, which is a combination of blue hydrogen, CCS projects, and other emissions reductions, and that it would be emissions free. They said it's the first case of its kind in the world because they're using consumer and corporate laws to challenge the veracity of a fossil fuel company's claims. And that's true because these are normally laws that are enacted by the ACCC. So the ACCR engaged the Environmental Defenders Office to act on their behalf, and this is, as a civil case, the outcome is a fine, not a fine, but if proven, significant undertakings about future conduct and reputational damage. So it's important that the case also establishes some level of case law around these issues. Santos defended the claims. I was engaged by the lawyers to provide extensive expert witness testimony. That was nearly a year of my life, and to engage with the ACCR expert witnesses in preparing joint expert witness reports to the federal court, and we were cross-examined extensively in the federal court in late November. This case has now been completed and we're awaiting a judgment by the federal court judge, Her Honour Bridget Markovich. The Santos roadmap to emissions reduction is at the centre of this case, Scope 1 and 2, and also Scope 3, some of its customers. And that was an important part of the case as well. Hydrogen, blue hydrogen being provided to largely industrial customers, let's say, they would, under the NGES scheme, receive, for example, a zero emission outcome, even though there would be emissions still at Moomba. And this was a main part of what was being litigated. As you can see, the mainstream media were very, very interested in this case. There was reputational risk involved for Santos. Probably at the back end of this is really a social license issue around what we can and can't do in terms of discussing transitions to net zero or to some level of low emission outcome over a period of time. So I've no doubt this will be a landmark judgment, and it will actually give some direction, I think, for people that are thinking about their transition plans and how they will communicate those to the public or their investor base. This case also covered a lot of gases. So it covered green hydrogen, blue hydrogen, and blue hydrogen produced in different ways. It covered CCS, and it also covered biomethane and synthetic methane production. So in late 2023, I published a paper on greenwashing, which was some ideas from what I was getting from some of the cases I deal with. And these were things like don't jump the gun, track what the regulatory authorities are doing, be careful with your public statements, think about your forecasting, how you're going to provide evidence around it, and also understanding the trigger issues. What are the issues that trigger off people saying it being deceptive and misleading? Things like using the terms net zero or zero emissions and how you're using them and what you're making claims about. Just think it out. And shortly after that, the ACCC published a guide for business along the same lines, which we'll cover next. If you haven't seen these, the ACCC's 8 key principles, it's very good work. It's very on song for what I've seen. Firstly, be accurate and truthful, provide evidence, and I think we can come back to that later. Evidence is really important, and understanding what evidence is. Don't hide or omit important information. Qualify what you're going to say. Be careful with unqualified or broad claims or marketing claims, and use easy to understand language. And visual elements are just as important as the written word. So be direct and open about your sustainability transition, but really, really be thorough, because that's not easy to do. And there's now a new overlay of the ASB sustainability mandatory reporting, so that should help in some ways as well, I think. And Santos' case may also shed some light and some guidance on what can and can't be said publicly, particularly, and maybe some of the technical issues. Continuing with that theme, of course, it's wise to track the regulators, the ones that can take action in this space, like the ACCC and the ACCAN as well. And they have major investigative powers under the consumer law, Australian consumer law, and they can seek large fines, up to $50 million. They can make or bring binding undertakings, etc. In March 2023, the ACCC did a good study called Greenwashing by Business in Australia. They looked at 247 businesses, and some 25 of those were energy companies. They were very concerned because their initial sweep showed 57% were making concerning claims. In the energy sector, 16 out of the 25 raised concerns, and that's their words. Now, the ACCC can issue a substantiation notice requiring you to give information and or produce documents that will be capable of substantiating or supporting your claims, and that's usually a first step. So they have a lot of power to do this in a stepwise format before anybody ends up in court. And the thing to recognise is that they've made a priority for their 2025-2026 enforcements around misleading pricing and claims in relation to essential services, with a particular focus on energy and telecommunications. And in May 2024, the Environmental Defenders Office also lodged a complaint with the ACCC, complained about potential greenwashing by the Australian gas networks, and that was related to renewable gases, for example. So what can we learn from these cases? What I'm going to show you today is from an expert witness perspective. It's not a legal perspective. It's a very different perspective from the lawyers, but it is somebody that's had to go through copious amounts of thinking about how to advise the court independently about such matters. Firstly, these cases take a lot of time. This case actually went from August 2021 through to November 2024, and we still don't have a judgment, and in the middle of that we had to change a judge. So the legal system takes its time, but it grinds pretty finely. It consumes a lot of management and key personnel time, and that's important for businesses to understand, and I'll come to that later on. They also cost a lot of money. You need good lawyers, you need even better senior counsel and King's counsel. There's a lot of time and energy goes into also instructing us as experts. We have to know the process, we have to follow it without bias, we have to be strictly independent, and of course it helps to be a little bit battle hardened, and you get cross-examined by Australia's finest. It does grind extremely fine once you get to the court case. Santos received a $9 million cost order against the EDA for its case in WA. This was a failed challenge to the Barossa Gas Project, along with some scathing comments from the judge, which I won't go into, but it's important to understand even that case, costs were awarded at a level of $9 million, and I suspect that's pretty normal. They're also incredibly technical. I and two of my colleagues spent some 9 months fully producing over 100,000 words of expert witness testimony. There was workbooks, there was our report, there was responses to reports, there was joint expert reports to the courts, and I can tell you in most of these cases I will read thousands of pages of material. The other thing that comes as a surprise to some groups that go through this process is the powers of discovery, and it's very potent, nothing's off limits. In such cases I get to read lots of confidential material, emails, etc. And Facebook and LinkedIn material has also been used in cases, so everything's out there and open in the public, is available, plus they can subpoena all sorts of other information from you, and that subpoenaing can go on and on and on. I also get to regularly relive many of my old publications, and probably this presentation as well, and sometimes to even comment on my old material, because they are looking back in my history to see if there's any bias, and that's fair enough. Things like voice recordings, adverts, blogs, speeches, etc., they're all discoverable, they're all used in courts, and so everything you say and put out there doesn't disappear, it's available for these types of cases. So always remember that when you're talking about how you're doing things, make sure you've got good evidence of how you've arrived at what you've said, and you've got support for it. The other thing that I've learned is the legal context is very specialised. I don't fully understand it myself. What you may think is fair may actually be a little weight in court as it relates to the allegations being made at law. What are the clear, defined allegations? Which law have you broken? The court will want to distill that down. In this case, we saw lots of issues associated with people really complaining about policy, not about law. So they were unhappy about the way certain regulatory things could work, but in fact they could work that way because they were allowed to work that way under regulation. But at a policy level, people disagreed with it, and that was teased out very well in the court. And so don't think that policy, don't confuse policy with regulation or legal requirement, and that is quite often done. Assumptions are just that. They're not matters of fact. Any assumption can be pulled apart. Experts can argue over it at length. An opinion must be based on some level of real evidence. And experience counts, but without supporting evidence, it is just an opinion. So opinions backed by reasonably strong evidence have a lot more force within the court, I've found as an expert witness. And so when you seek opinion from anybody, if you want to, prior to publishing or doing anything publicly, then please do so and ask about the evidence behind it. Statements about matters must also be checked for validity. And I think that's me today. Thank you very much.